In response to your answers to several people, including Representatives McKinley and Pompeo, I would just have to point out that the Virginia State Corporation Commission does not agree with you that this is going to somehow make the price of electricity go down. And I quote, "To achieve the carbon emission reductions required by the proposed regulations, customers in Virginia will likely pay significantly more for their electricity. The incremental cost of compliance for one utility alone, Dominion Virginia Power, which only serves 2 of the 29 jurisdictions I represent, would likely be between $5.5 and $6 billion on a net present value basis. In addition to new investment, Virginia residents and businesses will also be responsible for paying remaining costs for useful existing facilities forced to retire prematurely under the proposed regulation. The proposed regulation places at risk several billions of dollars of recent investments in existing coal-fired facilities. Contrary to the claim that rates will go up but bills will go down, experience and costs in Virginia make it extremely unlikely that either electric rates or bills in Virginia will go down as a result of the proposed regulation." Now, I assume that you're aware that the Virginia State Corporation Commission is not some private body of electric generators. That is the regulatory agency that sets the electric rates in Virginia, that says what the companies can charge. And they say, just to one company, it's going to cost $5 to $6 billion. When you add in all the other companies, it's going to be billions, and that it is highly unlikely that the rates will go up, but the bills will go down. They said extremely unlikely. Let me get it correct. I said highly. They said extremely unlikely that either electric rates or bills in Virginia will go down as a result of the proposed regulation. So I just point that out to you, so when others say, please listen to these folks, they have decades of experience in figuring out what the rate is supposed to be so that the electric companies don't charge too much, but get a return for their heavy investment. Now, that being said, you also indicated that folks were moving to gas-based generation as it's more affordable. That is true today, although even last year for a number of months the rate was over. The cost of natural gas was higher than that which would cost to create the same number of BTUs with coal. That fluctuates, but further, you have to build pipelines. Now, right now in my district, there's a big pipeline being proposed to be built, and in the non-coal producing areas of my district, people are opposed to that pipeline because they're not sure that at that size it's going to be safe. So I submit to you that we may not be ready in 2020. And further, I would ask, don't y'all work with the DOE? Because they're working on clean coal technologies, and they have indicated to us that it will be probably about 2025 before those new technologies are on board. But according to your plan, at least as we've heard about it up to this point, you keep pointing out it's not final yet, the states are supposed to come up with their plan 13 months after the final rules. So this is 2015. Sometime in 2016, Virginia's going to have to come up with a plan. They can't wait until 2025 when the new technologies will be viable, and there's 5 or 6 clean coal technologies that look really promising. How much greater benefit are we going to get as a society in that 5 or 6 or 7 year period that we're going to put lots of people out of business, raise the cost of electricity, and yet the technologies are almost there? I would submit the plan is flawed, and that's why we need this bill. I would also say to you that, and I would have to ask this from a legal standpoint, if one state were able to pull out of your plan under a legal theory, would that destroy your plan? Yes or no?
It would be inconsistent with the way the Clean Air Act works, and it would be disruptive.
But you understand that Lawrence Tribe, when he was here to testify, I asked him about collateral estoppel on the case that I asked you about last time, where the EPA lawyers conceded that you didn't have the power under 111D to do this regulation. He said collateral estoppel would only work, or res judicata would only work for the state of New Jersey if they chose to use it. You could lose on that point. Now, I don't think you're right on 111D anyway. I don't think you have that authority. It's interesting, though, that this bill would say that all of these cases would have to go forward, but this Thursday you're arguing in front of the Circuit Court of Appeals that it's premature to bring the court case that says you don't have the underlying authority. Wouldn't it be great to go ahead and get the Supreme Court to decide whether any of this regulation, final or otherwise, whether you have the authority to regulate at all under 111D the existing power facilities, electric generation units? Wouldn't that be great to go ahead and get that out of the way? And why would you all want to stall that And wouldn't this bill, if passed, encourage you all for judicial efficiency to go ahead and let's find out whether or not you have the power to do what you say you do? I don't think you do. You think you do. The Supreme Court has yet to rule. The more you delay makes this bill more practical. Your arguments on Thursday make me want to carry this bill. Thank you very much, and I yield back.
This time, I recognize the gentleman from California, Mr. McNerney, for 5 minutes.
Well, thank you, Mr. Chairman. Ms. McCabe, I've